Hi, I'm Greg Hunt and welcome to No Disputing That. I created this podcast to give you an in-depth look into the world of mediation and arbitration. Each episode I'll be having a conversation with one of the most renowned names in the field, plus some you may not have heard of yet. We'll cover a wide range of topics from ADR to other areas of the law and life in general. So get ready for a unique blend of thought-provoking discussions, plenty of laughter and occasional audio slip-ups. Welcome to episode 19 of No Disputing That. In this episode, I'm joined by Marcus Rutherford, and Marcus and I are going to be discussing the travel arbitration scheme. The idea of this podcast is to make it available as guidance for consumers and other interested parties who may be preparing to use the scheme or would like more information. I'll introduce Marcus in a second, and hope you find this podcast of use and information. I do mention at the end, and I'll mention it here now at the beginning. You can also view frequently asked questions about the scheme at www.travelarbitration.co.uk. Thank you. Welcome, Marcus, to this episode of No Disputing That, where we are going to be discussing the travel arbitration scheme and answering some commonly asked questions put to us by consumers and other people who are interested in the scheme. So Marcus, you are someone I've known for quite a long time now. I'd say probably since 1995, which is when I started the Chartered Institute of Arbitrators last century. You're a very well-respected arbitrator. You've been a panel of the scheme for years. You're a retired solicitor, an author, a painter, probably a million other things, but someone who I certainly look to for advice and guidance a lot, not just on this scheme, but generally in my activities in ADR over the last 28 years. So welcome to the show.
Thanks, Greg. Thanks. It's very, very kind of you.
No, not at all. Not at all. It's very kind of you to do it. So the idea of this podcast today is that we're going to go through some questions and comments that people have put to us about the scheme, the travel arbitration scheme, with the intention of providing some guidance to consumers who are going to use the scheme in the future. Okay. And I think one of the most sort of highly asked questions that we get is, what is arbitration?
It's interesting because the traditional way of dealing with disputes over contracts or various claims is obviously to go to court. But arbitration is a sort of private dispute resolution system. So it allows people in dispute to avoid having to use the court system, but still get a decision by an independent third party, which is capable of being enforced by the courts. So it has the advantages of being a judicial type system, someone sitting there listening to both sides of the argument, but it's slightly more user-friendly, the cost can be less, and it can be quicker as well. So it's a useful way of privately resolving disputes.
And in the context of the travel arbitration scheme, it's a documents-only process which allows consumers to submit the documentation that they want the arbitrator to consider online or by post, and means they don't have to go to court and stand in front of a judge and so on to go through the process.
Yes, and that helps bring the costs down because obviously if you're going through a court system and there's going to be a hearing in court before a judge, just getting people into court on the same day together is a costly process. And if you can resolve disputes relating to contracts and simple disputes within the travel industry, if you can do that online by looking at documents and dealing with things in a modern electronic way, it dramatically reduces the costs for everybody involved.
Mm. Mm. And let's look at cost now then, because again, it's a common asked question: how much does it cost? So there are two different elements to costing for consumers for using the scheme. For claims under £7,500, which is by far the majority of claims that come under the scheme, the average claim value is somewhere between 3,500 and 4,000. So for all of those claims, the cost is £90 plus VAT, which is £108. And for claims which are more than 7,500 and under 25,000, and these tend to be big family holidays to big international resorts or cruises, worldwide cruises and things like that. The cost is £112.50 plus VAT, which is £135. So they compare very favourably to the costs associated with going to court, which can be significantly higher, especially once you've gone through the whole process of the court action.
Yes, and often in court, people feel that they must have lawyers to help them through the process.
Mm.
And the scheme is designed in a way to be simple enough for people to use on their own without lawyers.
Yeah.
And of course, one of the great benefits of the scheme is that if you make a claim and you win, you get more than the travel company has offered to settle the claim. You'll get your fee back. So it would end up costing you nothing to get your claim determined.
Yeah, I should add there in all openness that if you were to lose your claim, which would be if you were to be awarded nothing or you were to be awarded less than had previously been offered by the travel company before arbitration, then you would need to make a reimbursement to the travel company to the amount of what you paid as your claim.
Yes, but at the same time, that's true. But at the same time, the costs rule follows that of the courts, that the losing party pays the costs of the winning party.
Yeah.
But it's capped, it's limited to the amount that you paid for the fee to start the process. So unlike in court, it actually has capped the fee, even in circumstances when you lose.
Yeah, excellent. Okay, now this scheme's been running since the 1960s, believe it or not. And I know you've been involved with it a long time, probably not quite far as back as that. It covers many different types of disputes, but what would you say were the most common types of disputes that you see going through the scheme?
The most common, I suppose, are people who book their annual holiday, the family holiday, often some months in advance, sometimes a year in advance, with enormous expectation as to what they're going to get when they go on holiday. And then for some reason or another, they end up being disappointed. Disappointment is not something that on its own gives rise to a claim. You do need to be able to prove that the disappointment amounted to a breach of contract. In other words, if you were promised a hotel with a sea view, and when you got there you didn't have a sea view, or you were promised all-inclusive facilities and half the resort was shut, those disappointments are breaches of contract which would entitle you to compensation. So it's those sort of situations which arise. But within that sort of holiday, the range is huge. It can be from building works that are going on at the hotel, to problems over all-inclusive holidays, to problems to do with the flights, to problems to do with the way that the the problem on holiday was handled.
Mm.
Was it managed in the best way by the tour operator while on holiday? Those are the sort of things that can happen.
Yeah, you mentioned flights there as well, and I think other schemes do exist for flight delays and cancellations under the Civil Aviation Authority regulation.
They
But
do.
yeah,
They
for our
do.
scheme, it's more about if a flight delay or cancellation is part of the overall claim to do with the package, then we can handle it. But if it's purely just to do with a flight delay or cancellation, you need to go to a different scheme.
I think that's right. I think the scheme came out of the package holiday revolution, as you say, in the
Mm.
60s, when people were wanting to go on holiday, not wanting to have to spend time separately booking flights, separately booking accommodation, and a number of travel companies were offering the package. They did
Mm.
everything for you. They got you to the hotel, they got you the sort of accommodation you wanted, and they got you home again. But the problems did happen in those
Mm.
situations. There needed to be a way of resolving those problems, which was actually fair, cheap, and easy for consumers to be able to negotiate. So
Mm.
that's really the genesis of the whole travel arbitration scheme.
Yeah, yeah. And I think linked into that as well, in relation to there are times when we can deal with flight delays and cancellations. There are also times when we can deal with personal injury and illness claims as well. So in respect of that, there are limits within the scheme. So if you have a personal injury claim or an illness claim and you want to use the travel arbitration scheme, then you can only apply up to £1,500 of the claim per passenger for that particular illness or injury. And it can't be more than half of the value of the claim. So if I was applying, say I went on holiday with my wife and 3 children, and one of the children was ill, and I wanted to claim for the illness, I said it was caused by the travel company. If I made a claim of £1,500 for that and it was all to do with that illness, I can't use the scheme for that. If my claim was for £5,000 and included elements of other issues within the holiday, then I could make a claim of up to £5,000, up to £1,500, sorry, for the personal injury or illness element of that.
And there's a good reason for that. When you're dealing with a breach of contract claim, you're dealing with a loss of value in the contract. In other words, you paid £3,000 for a holiday, but a lot of the facilities were missing. So you've lost value from the contract. When you're looking at personal injury or illness claims, there are much potentially longer term consequences. Somebody may have to take time off work. It may have long term impact on someone's health. And so the way of assessing the value of those claims is different to a normal breach of contract claim. And it's really important. I mean, it's important in any claim to be able to produce evidence to support the problems that you've had, but particularly for things like illness and injury, it's really important that you produce the right sort of evidence to support the losses. Otherwise, you could end up losing out on something really quite significant.
Yeah, yeah. Okay, now something else we're asked quite a lot, so it's worth dealing with head on, is how does it all work and how long does it take? So I'll run you through the process, and then Marcus, you can add anything else as well before we move on to the next question. So basically, travel arbitration is an arbitration scheme, um, in the main, to resolve disputes between consumers or holidaymakers and members of ABTA. Although there are different schemes that exist for love holidays on the beach, Southall travel, and one or two others as well. Although the rules are pretty much 100% the same, but they do vary in some places. But we're going to concentrate at the moment on the ABTA members scheme for the rest of this podcast. So basically, a consumer goes on holiday and you have a problem. You're then to report that problem to your rep. And I know that travel companies now have different ways of reporting those problems. So there might be a rep on site, or there might be an app and you report it through the app. But whatever you do, you need to report the problem at the time and give the travel company the opportunity to rectify whatever the problem is. So say that all happens and then you come back from holiday and you're still not happy, you didn't feel it was dealt with properly or at all, then the next step would be to complain to ABTA. At that point, ABTA have an informal conciliation process, and they try to resolve the complaint between you and the travel company. If it's still not resolved at that point, then ABTA give you a further two options. One of them is to go to the small claims court, and the other one is to go to arbitration, which is the travel arbitration scheme. It's important to make that point now as well. Sometimes people say to us, we didn't have any choice but to go to arbitration. We didn't even know what it was. Well, there is a choice. You're very specifically told by ABTA you can go to the small claims court or you can go to arbitration. So anyone who elects to go to arbitration has made that choice at that time that they're going to go to arbitration rather than go to the court, and you can't do both. When an application for arbitration is made, 90% of the time it's done online on the portal for applications, and the holidaymaker will upload the documentation, give some details that we ask for questions about the arbitration process, and then we gather all that information in. That's all then sent to the other party, who at this point are called the respondent, but the travel company. And they're then given 28 days to submit a defence to what the allegations about them have been. That defence is then sent, a message is then sent back to the consumer that there's a defence on the portal for them to comment on. And then the process ends with all the documentation being viewed by the arbitrator. Marcus, do you want to pick up from the point where the arbitrator then gets all that evidence and what they then do next?
Sure. So the job of the arbitrator is to look at the evidence and to decide on the evidence that's produced whether the claim that's being made by the claimant is going to succeed or not. And if he thinks that there's been a breach of contract, then the arbitrator will go on and make an award of compensation. He'll work out what he thinks the right sort of level of compensation is. So it's quite important, given that the claims are almost always to do with the contract that was entered into, it's important for the parties to make sure that the arbitrator is given the contract so that he knows what the promises were made about the holiday that was booked and paid for. And he can then measure against the promises whether the things that the holidaymaker is complaining about actually amounted to breaches of contract. So that's the sort of process that he will go through. And the more information that he's given, the better. The evidence that is usually produced is obviously the communications, email, text communications between the holidaymaker and the travel company on holiday and on the return. It is also the booking forms, booking conditions, brochure if there is one, online brochure, online information if that's how the booking was made, photographs, videos, recordings, witness statements. Those are the sort of things that an arbitrator will want to take into account to see whether the complaints that the holidaymaker is making are justified. You know, if there's a complaint about building works, it would be good to have a couple of photographs showing the extent of the building works so that the arbitrator can have some sort of idea how much it would have affected the holiday that was being taken. So it's really all common sense. It's really understanding that the arbitrator needs to do a little bit more than just accept your word for it as the holiday maker, that the holiday was a spoiled holiday. It's not enough to say I went to Spain and it was absolutely rubbish. You have to be specific, and you have to show why the spoiled holiday didn't come up to the promise that was made about it.
So the burden of proof, the onus of proof, is on the consumer to prove their claim.
Yes, it is. It's again, that's no different from in court. So it's not something, that is imposed by the arbitration process. If you're making an allegation that the food was terrible, you really do need to produce some sort of evidence to show that the food was awful, and not just something that was specific to yourself or your family. So I think uh, it's very much common sense as to what should and shouldn't be put in front of the arbitrator. And the more you can give an arbitrator to support what you're saying, the more likely it is that he will be able to make a fair decision.
So for a consumer, don't be shy. Make sure you include everything that you want the arbitrator to consider. And it needs to be at the point where you're making your claim. You can't add information later on. It needs to be everything up front.
Yes, but because it's a very streamlined process, it's not an ongoing investigation. The arbitrator's not there to investigate on his own account what did or did not happen. It's really important that he's given all the information that supports the allegations being made. If there's complaints that the room was dirty, that the hotel was badly managed, that it was meant to be all inclusive, but breakfast was never available. That sort of thing needs to be supported by some sort of evidence in order to maximize the chances of succeeding in the claim.
Mm, mm.
It's the same as in court. So, I mean, anyone listening to this podcast, the same rules would apply in court. You can't just wander into a court and say to the judge, "I had a rubbish holiday," and the judge will say, "Oh, well, that's fine, to have a couple of £1,000." It doesn't work like that. A judge has got to be given enough evidence that he can be satisfied that the claim is a good one.
And what if the defending party, the travel company, what if they don't make any defense? Does that automatically mean that as a consumer I would win?
No, it doesn't quite work like that, because although in court there's a default judgment process. In other words, if a travel company fails to put in a defense, then the claimant can get a judgment for the amount that he claims. With arbitration, the arbitrator still has a duty to look at the claim to see whether on the face of it's going to support the conclusion that there's been a breach of contract and the level of compensation to be awarded. So the arbitrator will still look at the merits. Obviously, if it's the claimant who says, we were promised XYZ and we didn't get XYZ, and there's no answer to that from the travel company, the arbitrator is going to accept what the claimant has to say, because he's got no reason to believe that the claimant is lying on the face of it. Claimants don't go into this process just out of sheer cussedness. Most
Mm.
of them feel quite strongly about the claims that they make.
Yeah, yeah. Okay, so that whole process from gathering the information and getting to the point where an arbitrator is appointed, I suppose it's important then to backtrack slightly and look at who the arbitrators are, because they're not judges, but they have a wealth of experience in travel-related disputes, built up over many years. Um, from my point of view, as the person who runs the scheme and Hunt ADR as the business. Um, all arbitrators on the panel are either members, fellows, chartered arbitrators of the Chartered Institute of Arbitrators, or they've at least undertaken all of the training, including the award writing element of that as well. And those who are new to the panel have a number of cases monitored before they are full panel members. Do you want to give any more background of a typical arbitrator?
Yes, I think they're people who've been on package holidays, so a lot of them, but certainly understand the sort of things that can go wrong, um,
Mm,
because a lot of them have done a lot of cases. I mean, I know a few arbitrators who've done over 800,
mm,
some over 1,000 travel arbitration claims. Because they've done so many, they've built up a body of sort of experience, which often isn't replicated in judges, because I suspect that you know, over the years there've been more claims that have been dealt with by arbitration and by arbitrators dealing specifically with these types of claims. So
mm,
I think it's an advantage. They by and large know what they're doing, and one of the real benefits of the arbitration scheme is that the arbitrators are not just making an award of compensation. They're not just saying, I've looked at the papers and I think the claimant's entitled to £2,000, but they're explaining the reasons behind it. And
mm,
this is really important, because if you are not getting as much as you think you're entitled to, or if you're a travel company and are having to pay more than you think you ought to be having to pay in compensation, you really do need to, I think you're entitled to understand what the reasons for that are.
yeah.
So I think, you know, the Arbitration Act, the law that allows arbitrations to take place alongside court process, the Arbitration Act actually requires arbitrators to set out the reasons for their decisions. So I think it's a really good thing for people to understand the process and how the arbitrator got to the decision that he got to. Sometimes they go wrong. Sometimes, you know, a lot of it is to do with as a judgment call. And different arbitrators have a different view, particularly in relation to the size of compensation. But if you can actually understand how this arbitrator dealt with this dispute and awarded this amount of money, it's at least a starting point to be
Mm,
able to feel you understood why you didn't win as much as you thought, or you didn't win.
yeah, yeah. And we're talking about here about, you know, an arbitrator producing something called an award. So it's probably worth explaining to people what the award is. So it's a document, a legally binding document subject to rights of appeal, which we can talk about in a moment. But it sets out at the beginning of the award um, who the parties are, what the dispute's about, the story behind it, really, the history of what's happened, before making an actual decision about what is going to be the outcome of the dispute. And then, as you just said, Marcus, very importantly, giving full reasons and setting out in clear English why a particular party has won or lost, not just as a global output, but on every point of claim that was made.
Yes, because a lot of people have problems on holiday, which doesn't go quite to the way they expected it to go, and they come back slightly unhappy. And they might think that that unhappiness means that they're entitled to compensation, but of course it isn't. Like a holiday isn't like an M&S jumper. You can't just take it back and get your money back. You actually have to show that there has been a breach of contract, that you didn't get what you were promised when you booked the holiday. And so it's really important to understand how the arbitrator actually reached that decision, so that you can, the next time you go on holiday, you may learn the lesson, and may learn to produce more evidence, or learn that you need to complain at the resort before making a claim for compensation when you get back from the holiday. It's important to make sure that you do what you have to do during the holiday to lessen the impact of any problems that happen.
Yeah, and although this is a legal document, we have outlawed use of Latin. And we also make sure that it's very understandable. People can read it and understand exactly why an arbitrator's made a particular decision, which is really important. Of course, even though the arbitrator reasons the award sometimes, and it's not very often in context of how many cases come through the scheme, sometimes one of the parties still isn't happy and wants to appeal. And we've got two routes to appeal. One of them is through the scheme, where we appoint an appeal arbitrator to look at the information and make a decision based on whether or not an arbitrator should have reasonably made that decision with the evidence that was presented to them. And the second option, which you can still use if you're not happy with the outcome from the first, is to appeal through the courts, which is a very painful process. And you'll know more of it than I do, Marcus, as a solicitor, but not really something that is very easy for a normal person on the street to do through an arbitration award.
It's hard to appeal an arbitration award,
which is why we introduced the scheme appeal. Yeah.
Yes, because people do have different views. It's particularly in the amount of compensation. When you're trying to value, let's say you've got a holiday where you were promised a room with a jacuzzi attached to the room, and the jacuzzi's broken down. That's going to spoil your holiday. You were promised something, and it wasn't there. So you're going to be entitled to some measure of compensation, but different arbitrators will have a different view as to what the value of that claim is. Some might think, well, 20 quid a day will compensate for that. Others might say, well, it's you could still have used the hotel sauna and other hotel facilities, so it didn't impact that much on your enjoyment of the holiday. So it's inevitable, people being people, that you will have different views, and it's only really where an arbitrator gets it very, very wrong that you're going to be able to get a successful appeal. And it happens. It isn't common, but sometimes the law is misapplied, particularly, and I'm sure we'll come on to it, particularly in relation to the award for compensation for loss of enjoyment of a holiday, which is very specific to holiday claims. But that's an area which even in courts has given rise to to a great deal of difference of opinion. So there will be differences, and all we can do is to try and have a process which evens out those differences and makes the process as understandable as possible. If everything was absolutely certain, if you knew that you were going to get X in relation to a breach of contract, specific breach of contract, if X was the right figure, you'd never have disputes, because the travel company would know as well as you do that that's what the amount is that's going to be awarded. So it is a process of trying to get to as close as possible to the right result.
Yeah. Okay. And just on the context again of appeals, unfortunately, people can't just write to me and ask me to change an award. Just like you wouldn't be able to write to the court staff and ask them to overturn a judgment made by a judge. Hunt ADR has got no authority to change an award. So the only way to have an award looked at once it's been published would be to use one or both of the appeal mechanisms that we were just discussing. If you wish to complain about the time it took, or the administration, Hunt ADR staff, etc., then we do have a published complaints procedure. But in relation to the actual content of the award, there is nothing we can do. It has to go through the appeal process. Okay. Sorry, go on.
I think also that's in part a function of the independence of the process.
Yeah.
Obviously, if what you're doing is you're putting your dispute to somebody to decide between a travel company and the holidaymaker, you want to make sure that the person doing that, deciding the dispute, is independent, and this is really an important part of the process, because I think what you're doing with the administration is a purely sort of administrative function. You're not involved, you and your staff at Hunt ADR are not involved in the decision-making process. That is an independent arbitrator, someone like me. I can reach whatever decision I think is appropriate on the facts that come before me. I don't belong to a travel company. I've got no reason to make a decision in favor of the travel companies. I'm independent of ABTA. I'm independent of the travel companies, and I'm independent of you. You're just there to administer it. And I think that degree of independence is quite possibly the most important part of any arbitration process, in order to have in order for people to feel confident in the process. It's really important that they understand that independence. People from time to time will try and pretend there's the connections between the various bodies involved, but in my experience, that's simply not the case. I don't think I know of any arbitrator who's made a decision because he thinks that he's in the pockets of the travel companies or of any other consumer body or anything like that. You look at the evidence, you decide on the basis of the documents that you have in front of you.
Yeah. And I think, this level of independence is really important, and you're right to push it home. I think people don't really always understand, because why would they, if they're only ever going to be using the scheme once, about the different levels of independence. And it even goes as far as sometimes people will say, well, the arbitrator will find in favor of the travel company because they pay him. Well, they don't. And the travel company pays Hunt ADR an admin fee, which is very similar to what the consumer pays at the beginning with the registration fee. Hunt ADR will pay the arbitrator quite often the arbitrator's paid and we've not yet been paid by the travel company. Whether the travel company pays us or not has got no impact on whether the arbitrator gets paid. It's a completely separate interaction. And I think that's important to make as well, because there is no way at all that anyone can say that the arbitrator's in the pocket of the travel company, because there's even this extra third wall in terms of who pays the arbitrator. And even if the travel company didn't pay us, which is rare, but has happened from time to time, the arbitrator will still get paid, and the arbitrator will never know that we've not been paid by that company. So I'm quite proud and quite proactive about the levels of independence that are in place to ensure that both parties are treated fairly throughout the process.
It is important, and it's different to complaining to a travel company after you come back from holiday, where the travel company's doing its own internal investigation and getting in touch with the hotel and asking what's happened, did this happen when the holidaymaker was there. This is one step higher in sort of level of seriousness, and so it is, as I say, to have confidence in the process. You do need to feel that the arbitrator is completely open-minded about the case that he sees in front of him. But as you say, I've been doing this for many years. It's in fact back to about 1982 I've been doing this. And in all that time, I have never come across any arbitrator who's ever felt that his duties lie towards the travel company or to a consumer group.
Yeah. And if that ever did arise, it would be clear from the awards and would be addressed immediately.
I don't think it would ever arise.
No,
I think that if for instance an arbitrator felt that he'd recently travelled with one of the travel companies, he'd probably turn down the opportunity to decide that particular dispute. So I think arbitrators recognise the need to be independent and don't put themselves in a position where even the suspicion of a lack of independence will ever arise.
Yeah, funny enough, for the first time that I'm aware of, and I've been involved in this scheme on and off since 1995, about a month ago, an arbitrator did actually withdraw from the arbitration on the basis that he'd stayed in the same hotel that the dispute was about in the same time period. And he felt that he would be making his judgment based on potentially based on what his own experience was, as opposed to what the experience of the claimant was. And he felt that gave him a conflict of interest and withdrew from the arbitration.
I think that's really interesting, and I think the arbitrator was right to do so, even though he would have had some first-hand experience of what the place was like. I think it's absolutely right that he should step back from it and allow the claimant to make the case that the claimant wants to make.
Okay, so everything we've talked about here now, this whole process, including the publication of the award, our target is that will take about 12 weeks. Now, it doesn't always run smoothly. Clearly, sometimes there are delays. Sometimes it takes longer purely because the arbitrator is requesting more information from the parties. And the time for the arbitrator to start considering all the evidence to publish the award starts from when the arbitrator's got all the evidence that they need. So sometimes it takes longer for that. Sometimes, though, it is admin delays, and we've got to be upfront and honest about that. More recently, and we're just about over the hill with this now, of course, we're dealing with disputes to do with holidays, and COVID happened. And when COVID happened, the holiday disputes and claims that we deal with went down I wouldn't even say significantly, if more significantly than the most significant you can think of. They just stopped because no one was going on holiday, so there were no disputes. And then all of a sudden, as quickly as they stopped, they started again. So we went from a position of obviously having not as many staff working on the scheme because there were no cases, to actually needing more immediately because cases went through the roof. So there have been some delays during 2023. So I apologise for that in this podcast. We feel that we're now up to date and we're back on track with most cases taken around the 12-week mark. So that just gives you an indication from the day that you apply to the day that you get the written award, published award from the arbitrator. The target is 12 weeks. Compare that to going to court.
Well, I can't remember the last time I went to court on a small claim, but it's considerably longer than that.
Yeah.
And obviously, if there's a hearing that needs to be arranged, it could be months and months and months.
Yeah. So I've just got two more things I want to say. I've got one more question I want to ask you, Marcus. So first of all, I'm going to say people contact us sometimes and say, this is my case. Can you tell me if I'll win? No, we can't. Okay, so the admin team, Hunt ADR, we're not qualified to give you an opinion on whether or not we think you'll win if you go to arbitration. Again, if you were to phone your local court and speak to an administrator and ask them if you've got a case to take to court, will you win or not? They won't know either. Okay, so we can't give you advice and guidance on that. I mentioned earlier about personal injury and illness claims. I forgot to mention that there's also a conciliation scheme for personal injury and illness claims. Now, if you are a consumer and you apply to go to arbitration, under the ABTA Code of Conduct, the tour operator, travel company, has to go to arbitration with you unless they settle. It's a binding condition of their membership of ABTA. They've got no choice. They can settle, obviously, but if they don't settle, they have to go through the arbitration process. With conciliation, it's slightly different. If you want to go to conciliation with an ABTA member for a personal injury or illness claim, they have to agree. Okay, so they get the opportunity to say yes or no. But it is there and it's available. And if you want to go to conciliation, which is where a conciliator works with the parties to try and find a solution which they both find mutually acceptable to move forward, rather than an arbitration where the arbitrator makes a decision which has to be lived with, even if both parties are unhappy with it. It does exist, so you can make an inquiry with your tour operator or ABTA about that. And Marcus, just something else I wanted to come back to with a question for you, and it's to do with offers pre-arbitration and how the arbitrator deals with that in the arbitration process, and the difference between a cash offer and a voucher.
Yeah. When holidaymakers have a legitimate complaint about a holiday, by and large, the holiday company, travel company, will want to try and settle the matter. So it will make an offer. It may not be what you want to see as an offer, but they'll, generally speaking, make an offer. Because what they want to do is to avoid the sort of dispute escalating to court or to arbitration. And the bigger companies have a pretty good idea of the value of the sort of claims that they generally see. So by and large, the offers that they make are intended to stop the process. If you can make an offer to a claimant and it's accepted, then that's an end of any sort of dispute. Obviously, if a claimant doesn't accept the offer and wants to take the matter to arbitration and see what an arbitrator will decide, he's free to do so. You can't really do both. You can't really accept an offer and say, well, I'm accepting the offer to settle this claim, and then bring the claim in front of an arbitrator. It just doesn't work. And so it's important, if you are rejecting an offer, to send back any money that may have been sent to you. The way that some travel companies operate is actually to send you some money to reimburse your credit card or something. And it's important, if you can, to get the money back to the travel company, or at the very least to make it perfectly plain you're not accepting the money in settlement of the claim that you made. Sometimes travel companies will offer vouchers, which effectively means that you get money off your next holiday. And if you want to accept that, that's absolutely fine. But vouchers are not taken into account in dealing with the sort of costs of a dispute. In other words, a voucher isn't necessarily money or money's worth. It's something that is offered in the hope of getting rid of a dispute, but it can't really be taken into account when an arbitrator makes his award and makes the costs order in relation to the award.
So if I'm offered £500 in vouchers, it's different to being offered £500 in cash when it comes to dealing with costs at arbitration.
Yes, because a voucher is conditional. It's conditional on you taking another holiday, and you may not want to take another holiday with that particular travel company.
Yeah, excellent. Okay, Marcus, I think that's all the questions I've got. Have you got anything you'd like to add?
I'd like to say this. I'd like to say, you know, although there is a very clear legal framework behind arbitration and behind the sort of consumer claims, the contract, and the approach, the contractual approach, a lot of it is very straightforward, simple, common sense. If you book a holiday, you've got the expectation that it's going to be, you know, an event that you and your family will get a very high value from. Annual holidays are really important for people, for families to spend time together. And so it's important that you understand that the damages, the compensation that you might get for a spoiled holiday might also include something for loss of enjoyment. But a lot of the issues that come up with these sort of claims. Now we have the internet, and there's virtually nothing that you can't search and do your research properly. It is really important for consumers, when they come back from holiday and they think they've had a raw deal, to do the research, to look into the rights that they have, and to be realistic about the claims that they can make and can justify. But you shouldn't be afraid of it. The information's all there. Even something like this podcast ought to be helpful for somebody trying to bring a claim. But do your research. It's important.
Yeah. And part of that, thank you, Marcus, is read the rules, read the application form, read the guidance. We've got additional guidance on the website, travelarbitration.co.uk. There are some blogs on there. There's the frequently asked questions section, which sets out a lot of detail. There'll be a link to this podcast on there as well. You know, it's difficult to provide good guidance and education to consumers because there's no central body of consumers, and most people will only ever use the scheme once, whereas we can talk to a whole travel company at the same time if needs be. So that's the idea of this podcast, is to help to support consumers who are thinking of making an application, listen to it in conjunction with reading the other documents that are provided, and hopefully it'll give you a sound basis for moving forward with your claim. For those of you who have not gone on holiday yet, the onus is on you if you have a problem on holiday to tell the tour operator, holiday company, however it's phrased, that you've got a problem. You need to give them an opportunity to put it right. And that would be sort of the best bit of advice I can give you if you've not been on holiday yet, which could lead to you never having to come to arbitration, because you've given the opportunity for the problem to be rectified on holiday.
Yeah, I think that's right. I mean, arbitration is very definitely the last stage in the process. It's everything else has failed. If you reach arbitration, it means you can't settle. You haven't been able to resolve the problem on holiday. You haven't been able to resolve the problem with the travel company, and so you haven't been able to mediate, conciliate. You need someone to make a decision as to who's right and who's wrong. So at that sort of late stage, if you've not been able to do any of the other things, you know, this is the process that will resolve that dispute, will bring it to an end.
Well, Marcus, thank you very much for your contributions today. I think it's been really useful. Hopefully it will help a lot of people who are thinking of going through the arbitration process. You've set out very clearly some of the different items and options involved in the process there. And I'd like to thank you very much for your time.
It's a pleasure. It's a pleasure, Greg. Thank you very much.
Okay, and I'll see you soon.
All the best. Take care.
That's all for today from No Disputing That. I hope our discussions have helped you to learn more about the world of mediation and arbitration. As we come to a close, I want to thank you for listening in and thank my special guests for their insightful advice and ideas. If you have any questions or feedback, please feel free to leave me a voice message and you might even be featured on a future episode. Until next time, this is me, Gregory Hunt, signing off. Thank you so much for joining me and have a wonderful day.